Okay, I have a question. Early on you said that there were rules that prohibited or that prohibit noise events limits, and so are you specifically referring to ANCA?
Yes.
Okay, and so is it your understanding that nobody can implement a noise event limit anywhere because of ANCA?
That's correct.
And so do you know why New York City was able to implement a helicopter operation rule that limited operations even with the existence of ANCA?
What the FAA did, and this is the Long Island route between Manhattan and the Hamptons, was that the airport didn't institute that rule. The FAA initiated that rule. So the FAA isn't withheld from ANCA. They control the airspace.
That's not. I'm talking about the New York helicopter case where they banned flights out of the 32nd or 37th Street heliport during nighttime hours and on the weekends.
I think that was the FAA action and not...
It was not. It was the City of New York. They were the proprietor and they banned it. The reason that they were able to do it is because they didn't take any federal funds. And so in researching ANCA, ANCA states that if you don't take federal funds, ANCA does not apply to you. The City of Santa Monica does not take federal funds, so ANCA does not apply to the City of Santa Monica.
Yeah, the heliport you're talking about was a private heliport.
No, it was city-owned heliport. They were the proprietor of the heliport.
That's correct. It was not an FAA licensed facility. So under the land use rules of a city, you, for example, could prohibit anybody from having a heliport anywhere you want in the city under your land use rules. You can deny a conditional use permit for a heliport. That's perfectly within your authority because they aren't a public use facility.
And so are you saying that's different from being a proprietor of the Santa Monica Airport?
Well, a lot has to do with who the proprietor is and whether or not you're operated under federal rules or under state or local rules.
So what is the difference between the City of New York being proprietor and the City of Santa Monica being a proprietor?
Well, you cited it. They don't have any commitment. They made no commitments to the FAA to operate that as a public use airport.
Correct. They didn't take federal funds. And if you read ANCA, the penalty for violation of ANCA is that you don't get future airport funds. It doesn't mean you don't have to pay back airport funds that you've taken. It only says that you are not allowed to get future airport funds.
Well, I'm going to refrain from answering what's in ANCA in terms of what you can and cannot get in funds. It sounds like you've mixed the grant agreement with what's in ANCA.
No, ANCA is very clear that if you violate ANCA, you're not entitled to any more AIP grants or you're not allowed to charge passenger fees. That's specifically what it says. It's a similar penalty to the grant assurance, and that's how the FAA dictates what you can do if you take federal money. But if you don't take federal money, then ANCA does not apply to airports.
Well, clearly, I'm an engineer, not an attorney, so I'm not going to interpret what the cost consequences are.
Okay, well, you cited earlier that ANCA restricted us from doing things, and I don't believe that it does. And one of my other questions for you is, everybody uses the term voluntary nighttime curfew. So do you or are you aware of why they say voluntary versus why it has to be voluntary, why we can't make a mandatory restriction?
Well, you certainly haven't been able to make a mandatory restriction on your arrivals up to date because you, in fact, still are under your grant agreements. Those have not expired yet, I don't believe.
It's actually the 1984 agreement that has the curfew prohibition, and so we agreed to that up until July 1st, 2015. After that time, it expires. So I'm asking the question, are you aware of anything else that prohibits us besides the 1984 agreement?
Well, I almost hate to bring this up, but I think I have to answer the question because you're bound to hear about it sooner or later. In 1984, and prior to 1984, a number of airports considering curfews wrestled with the aviation industry as to whether or not an airport could do that. That is before ANCA. This is in fact, it even goes back to the 1970s when John Wayne adopted its first curfew. John Wayne has a strict departure curfew, does not have an arrival curfew. San Diego has a strict departure curfew. It does not have an arrival curfew. The reason for that was that the stick that the aviation industry was waving around airports saying you cannot adopt curfews is because they will interfere with interstate commerce. So the strategy that was developed by all those brilliant legal minds back in the 70s and 80s was, gosh, if we adopt an arrival curfew, they might hit us with a commerce clause violation, a violation of interstate commerce. So because we're prohibiting an aircraft that may have crossed a state line coming into the airport and landing, we better not have a mandatory approach curfew. But a departure curfew won't violate interstate commerce because there is no way an airplane parked on the ground can cross a state line and just departing off of our runway. So the fad in the 1970s and 80s was to adopt a mandatory departure curfew and not an arrival curfew. And that was clearly the thinking that was still in place in 1984, that if you adopted a mandatory arrival curfew, you would get hurt with a commerce clause. And I can't tell you how many seminars and symposium I heard attorneys talk about the commerce clause. I mean, if you're bent that way, I suppose it's really interesting, but listening to the Railroad Act in the 1853 Santa Fe versus State of Nevada Burlington Railroad Supreme Court case on Commerce Clause, sort of, everybody's eyes glaze over when that comes into this. But that's the origin of voluntary arrival curfews versus mandatory departure curfews. And I know that was a thinking in 1984 was, how are we going to defend this if we get challenged?
So I believe that in New York Helicopter they sued under the Commerce Clause and it was struck down that it didn't violate the Commerce Clause and that the proprietor had the right to dictate both the arrival and departure curfews. So that's much more recent legislation than what you're citing.
Oh, when you hear attorneys talk about the Commerce Clause, they refer to a Supreme Court case. It's from the railroads in the 1850s. That's the legislation that that's the court rulings they reference for Commerce Clause rulings. And I am not an expert at that. I actually find it extremely interesting, but it's quite something to hear them argue that.
So it appears that that's dated and not a valid reason that
I don't think there's an attorney familiar with Supreme Court rulings that would agree with you with that at all, that their Commerce Clause rulings are going to go back to that case.
The courts have struck down the Commerce Clause claims and said that the proprietors had the right to implement those, and they didn't uphold the Commerce Clause. So that's the existing case law. So you're saying that you're not aware of anything subsequent to that?
No, and I'm not quite sure if that case is so general that it would apply everywhere or not. I would just render the caution that the aviation industry has many tools in their bag for fighting rules they don't want, and Commerce Clause is definitely going to be one of them that they'll bring to bear. And it certainly dominated thinking in the 70s and 80s. Now, the New York Heliport case may or may not apply to this case. I don't know. That's beyond my qualification to say. But I will tell you that it's not the last time you'll hear of the Commerce Clause.
Okay.